short introduction. Welcome all. I look forward to hearing what Emma and Adam have to say, and I now pass across to Emma to take the floor.
Thank you very much, Scott. Good afternoon, everyone. Now, Tom's going to put up the slides, hopefully soon. Great, thank you. So this webinar focuses on the money lending exceptions under the takeover provisions in the Corporations Act. Next slide, please. And I will be focusing on the legal and policy issues under the takeover provisions arising from the use of a company's shares as security for a loan. Because the taking of and enforcing security affects control over shares, there have been money lending exceptions in the corporate takeover regulatory regimes for many decades to facilitate this. My presentation examines unanswered legal questions and also policy questions remaining with respect to the scope of the current money lending exceptions. And I'll look at this in 6 parts. Firstly, the introduction sets out the regulatory context and also the significance of the legal and policy issues involved. Secondly, I'll give you an overview of the development of the money lending exceptions over time in 4 key stages. I've listed the legislation here for reference, and as Scott mentioned, the slides will be circulated after the webinar. Thirdly, I'll set out the key circumstances arising in the Takeovers Panel's 2019 decision in Doneco International Limited, particularly focusing on the unanswered legal questions concerning the impact of the lender's use of equity participation, in that case options, in secured lending arrangements covered by the exceptions. Fourthly, I'll be examining the current scope of the exceptions through an analysis of the case law and policy considerations. Fifthly, I'll provide some recommendations for panel guidance to deal with potential abuse of the money lending exceptions. And I'll finish with my conclusions in part 6. Next slide. I expect most, if not all of you, are familiar with the takeover provisions in the Corporations Act if you've logged on. However, I will start with a brief overview of the regime to provide a foundation for my later discussion. And this is a takeover law in 1 slide, so it is brief. The Takeovers Panel has the power to declare circumstances to be unacceptable and to make orders, even if the circumstances would not involve a breach of the detailed takeover provisions. And that is if the circumstances contravene the key purposes of the takeover regulation, which are set out in this slide. The first set of purposes have an economic focus, and the others focus on shareholder protection. Both are designed to ensure that there's an informed market for the buying and selling of corporate control. The last one is designed to ensure that shareholders have a reasonable and equal opportunity to participate in the benefits from the acquisitions of substantial interests. And this forms the basis of the takeover prohibition, which applies to listed companies and companies with more than 50 members. So these purposes are implemented through 2 key provisions. The first is substantial holding disclosure, which is required for listed companies. And this includes information with respect to the interests of persons and their associates holding 5% or more in a listed company. This is an early warning device prior to changes in control. The second key provision is the takeover prohibition, and this also applies below the control threshold. It requires persons to come within one of the exceptions to proceed beyond the 20% limit, and the key exception is making a takeover bid. These provisions are underpinned by a series of complex definitions, and the relevant interest definition is the most important for the purposes of this presentation. You have a relevant interest if you hold shares, can control the voting, or also can control the disposal of the shares, and this is where the security over the shares is important. In relation to associates, these include persons with whom you're acting in concert with respect to the company's affairs, including its control, and the voting power, which is used to determine the 20% limit, is a combination of the relevant interests of a person and their associates. Next slide. This means that lenders need to come within an exception in order to take and enforce security over their shares. The scope of the operation of these exceptions is important as it has the potential to significantly affect the availability of financing for business. There are two exceptions applying to moneylenders. The first money lending exception applies to the definition of relevant interests, and this was inserted with the definition of relevant interests in the New South Wales Amendment legislation in 1971. This exception applies at the time the security is taken or acquired, and it allows the lender to prevent the disposal of the shares by the grantor without needing to disclose the existence of the security or triggering the takeover prohibition at the 20% threshold. So this avoids the requirement to make a takeover bid. The second money lending exception only applies with respect to the takeover prohibition, and this was inserted with the 20% limit that was included in the first National Cooperative Scheme in the 1980s, CASA. This allows securities to be enforced even if the securities relates to shares above the 20% threshold. However, at that stage, you need substantial holding disclosure if it involves at least 5% of shares in a listed company. Next slide. This table summarises the historical development of the money lending exceptions in the takeover provisions and demonstrates how the operation of the exceptions has expanded over time. As I mentioned, the legislation is in full on the first slide, and I've highlighted in yellow the key elements of the current provisions for the purposes of the legal and policy discussion that will follow this. So looking firstly at the first grey column, this is where takeover regulation was in state legislation, and this applied an exception only to the relevant interest provision, which was the only relevant provision at that time, which applied to persons whose ordinary business included money lending, and the security was given for the purposes of a transaction entered into in the ordinary course of business. And we'll come back to the meaning of in the ordinary course of business in a moment. The second grey column sets out the provisions in the first cooperative scheme, which was the Companies Acquisitions of Shares Act, or CASA, which introduced the takeover prohibition and the second money lending exception. It also included a new requirement that the money lending transaction not be with a person associated with the lender, and that applies and still applies to the exception for the relevant interest provision. The third grey column sets out the substantial changes that were made to the Corporations Law following the Companies and Securities Advisory Committee report, the Anomalies report, that was in 1994, and this was reflected in the rewrite of the takeover provisions in the clerk reforms, which came into effect in March 2000. This introduced the requirement for the relevant interest and the takeover prohibition that the security be acquired on ordinary commercial terms. And finally, in the last grey column, there was a significant change to the Corporations Act in 2001, to the actual Corporations Act, which was expanded to apply the provisions to the provision of financial accommodation by any means. And that was a significant expansion, which I will talk about later on. Now, in the bottom right-hand corner of this table, you can see that there is also the addition of ASIC class orders in the context of the Corporations Act. And ASIC has used its modification power to modify the wording of the takeover provisions to extend the exceptions in these three areas. So firstly, to allow the exceptions to apply to where security trustees are used for the purchase of security and negative pledges. We will focus on the use of security trustees. Next slide, please. Although the Takeovers panel had referred to money lending exceptions in earlier decisions, its 2019 decision in Doneco was the first time the panel had focused on the detailed scope of the money lending exceptions in its decision making. The Doneco panel made a declaration of unacceptable circumstances and orders in circumstances where the lender had acquired 9.71% of Doneco shares at a time that it had the right to enforce its security interest over 27.25% of Doneco shares, being an ASX listed company. And at that time, the securities interest had not been disclosed to the market. This clearly involved an acquisition of a substantial interest in the company in an uninformed market, contrary to the policy purposes underlying the takeover provisions that I outlined earlier. However, the focus of this presentation is on the unanswered legal and policy questions concerning the use of the lender having options over 4.4% of Doneco shares in an option deed. The lender, in fact, cancelled these options prior to acquiring the 9.71% interest, and at that time, the options were grossly out of the money. Next slide, please. The Doneco panel left unanswered these key questions with respect to the scope of the money lending exception. Firstly, whether the exceptions apply and the extent to which they apply if the lender acquires an equity position as well as the security interests. And secondly, there is a policy question as to the extent to which this is desirable from a policy perspective, which the panel does raise in the decision. The arguments in Doneco focused on the first exception for relevant interests in section 609(1. And ASIC submitted that in the ordinary provision of financial accommodation, a lender is assumed to have no interest in the affairs of the issuer of the secured shares beyond those that impact its ability to liquidate the securities to obtain repayment of its debt. The panel considered finding that the relevant interest exception did not apply at all given the options. And this would have meant that the lender would have been in breach of the substantial shareholding disclosure and the takeover prohibition provisions. However, the panel declined to do this in light of, firstly, the legal issues surrounding the scope of the money lending exceptions, which is what I'll talk about in a moment, and the impact that this finding would have on non-traditional lending in Australia. The lender argued that it was commonplace for non-bank lenders to take equity positions and that approximately 80% of its global and 75% of its Australian debt positions involved it having some form of equity participation, either through direct holdings, options or warrants. Next slide, please. So to answer the legal questions, you need to determine the meaning of three key terms, which I've set out in the slide here. The first one relates to the meaning of financial accommodation, and the term in the legislation and also in the class order is the meaning of financial accommodation by any means. This term is very broad and was defined by Justice Hayden in Chameleon Mining as any means of supplying a want of money. Thus, this phrase doesn't place any limitation on the operation of the exceptions with respect to equity positions. Next, looking at the case law relating to ordinary course of business and ordinary commercial terms, and this is similar. In the Corommo case in 1991, the New South Wales Court of Appeal found that these terms were satisfied where a contractor whose principal business involved project management and consulting had also made loans of around $100 million and found that they had made those loans in the ordinary course of business and on ordinary commercial terms because they had borrowed money and lent money and made those loans in the ordinary course of business. Nor did it appear that there was anything exceptional or extraordinary in the circumstances in which they had made the loans. Importantly for our purposes, it was recognised in the Corommo decision that lenders may have equity interests in companies in which they lend money. And in a 1997 Journal of Banking and Finance Law and Practice article, former Takeovers panel member Dr. Nora Scheinkestel, my apologies, also discussed banks taking equity positions in their lending. As the wording of the money lending exceptions in the legislation and the asset class order allowed lenders to have equity positions, the key policy question is whether this can nevertheless lead to unacceptable circumstances. Next slide, please. On balance, the panel in Donegal found that the circumstances in the case did not prevent the lender from relying on the first money lending exception in section 609(1). And this was based on factors including the size of the security interest, the event of default, and the size of the acquisitions. Instead, the panel recommended that ASIC consider reviewing its class order, given its strong submissions on the issues raised, as the arrangements here involved a security trustee relying on the class order. However, the Donegal panel highlighted its remaining policy concerns, and this was concerning the use of section 609(1), the relevant interest exception, the first money lending exception, in respect of non-traditional credit arrangements that involve an equity component secured by a controlling stake in an ASX-listed company. These policy concerns are relevant to both the legislative provisions and ASIC's class order, and I suggest that the panel needs to provide further guidance in this area. Next slide, please. In my view, there are two clear circumstances that would be unacceptable based upon the panel decisions to date. The first one is if the lender and the person granting the security interest become associates after the security interest is acquired or taken. For example, this could be through a later proposal to control the company whose shares are subject to the security interest. And this is referred to generally in the Donegal decision in the reference to a control plan. Remember that the first money lending exception in section 609(1) doesn't apply if the lender and the grantor are already associated at the time that the security interest is acquired or taken. The Donegal panel found that conduct which is consequent to that time would not prevent section 609(1) applying on the letter of the provisions. And that's on the basis that the provision, section 609(1), is measured at the time that the security interest is taken or acquired. But it did note that ASIC could apply to the Takeovers panel if the lender's purposes are contrary to the underlying policy. Given this, I think clear evidence of a subsequent control plan would lead to unacceptable circumstances. The second situation is based upon Donegal, where the lender acquired an equity position at a time that there was a default allowing the security interest to be enforced, but this had not been yet disclosed due to section 609 subsection 1. And I argue that there should be a blackout period, making it unacceptable for all lenders who are using the money lending exception to acquire or exercise an equity interest at a time that its securities interest can be enforced, but the market has not been informed of this. This also gives rise to insider trading concerns. For the purposes of this guidance, the equity positions would include acquisitions of shares, options, and equity derivatives. It should also be generally unacceptable for lenders using money lending exceptions to acquire an equity position to the extent that the security interest and the equity interests combined exceed the 20% limit. And to work this out, I would argue, like options, this would be a notional process. You would bring forward the security interest to the time at which the agreement is entered into. So this means that you would work out the interest of the security at the time, and then look at the combined interests added to the equity position. Now, while there would be no limit on the percentage of security interest covered by the money lending exceptions, this would ensure that lenders could not use the exceptions to increase their potential level of control above that 20% limit if their security interest is already above that limit. Next slide, please. Accordingly, the general position on the money lending exception should be, firstly, if the security interest is more than 20%, I would argue that it should be prima facie unacceptable to acquire or exercise the equity position, as there is an undisclosed security interest over a controlling stake. If the security interest is less than 20%, it would only be unacceptable to acquire an equity position to the extent that the combined security interest and equity position is below or at 20%. As in the case of the Takeovers Panel guidance note on rights issues, the Takeovers Panel could set out exceptions to this policy based on the company's situation and the need for funds, if the company had obtained financial advice and sufficiently explored alternatives. However, I would argue that the 3% group exception should not generally apply to the lenders using money lending exceptions, as the creep exception is based on an assumption that the market is informed of the slow build-up of the control position, which is not the case here because there is an undisclosed security interest over the controlling stake. Next slide, please. In conclusion, this analysis establishes, firstly, in relation to the legal position based upon the case law, that the money lending exceptions allow lenders to take an equity position in shares subject to secured interests. However, I would argue that there needs to be panel guidance to deal with the remaining concerns that the exceptions not be used to obtain control over companies. And the Doneco decision has brought these issues to the fore, with concerns being raised as far back as the CASAC 1994 report. This guidance could be provided in a standalone guidance note or as an amendment to Guidance Note 1 on unacceptable circumstances. As discussed, I would argue it should be unacceptable for a lender relying on the money lending exceptions to firstly become associated with the person granting the securities interest after the securities interest is acquired or taken. Secondly, if the lender acquires or exercises an equity position where there has been a default under the security interest which has not been disclosed. And thirdly, if the lender acquires an equity position to the extent that the combination of its security interest and equity positions would exceed the 20% limit. I'll pass over now to Adam, who I'd like to thank for his contribution generously to the seminar. Thank you.
Thanks a lot, Emma. And I hope everyone can still hear me. I just had funny things happening on my screen. So
yes, we're fine.
Excellent, good, thanks. So yeah, Emma, it's been an absolute pleasure working with you on this presentation, and thank you for the really informative presentation that you've just delivered, which I think provides a lot of food for thought. And I must confess that when we first started working on this together, I hadn't probably had to deal in great detail with this money lending exception in the course of ordinary practice, other than in some limited respects. But in getting into it and looking at the Doneco decision, there's actually quite a lot of interesting sort of policy thinking and policy issues that this gives rise to. And I think the way I approach it is, at the end of the day, any exception to the substantial holding disclosure requirements or to the 20% rule is inevitably giving priorities to some other policy concern over the top of an informed market, or of the ability of those who hold shares being able to participate equally in acquisitions of positions that could give control or substantial interests. And so it got me thinking, well, what is it exactly that we're trying to protect here with these exceptions? And I think it's worth pointing out that we're talking here about lending activity which is secured by shares in ASX listed entities. What that means is that we're not talking about lending to Australian corporates or other listed entities. We're talking about predominantly lending to major security holders of those entities. And so, the importance of this, I guess, resides with there being a desire to ensure that where you have people with a high proportion of their wealth locked up in listed securities, being able to, I guess, use that to obtain liquidity, which can then be used for other forms of investment, which is beneficial for the economy overall. But I think it's worth sort of starting there, because you just need to remember that, why it is that we're doing this, and any of these exceptions, and they've been in place, as Emma says, for very many years, are inevitably going to erode some of the core principles that underlie takeover regulation in Australia. So the next thing that got me thinking is, well, who are the sort of types of lenders? And there's this kind of dichotomy set up in the Doneco decision between traditional lenders and these non-traditional lenders. And in Doneco, you had OCP, which is in certain circles, a very well-known hedge fund type organization that I know anecdotally absolutely provides lending or margin lending type arrangements, or other sort of creative or exotic lending arrangements where they might take security in unusual ways or non-traditional ways. But there's also a lot of global investment banks and local investment banks that provide funding for example, private wealth clients who might have very large holdings, and the complexity of those organizations and the different interests that they might acquire in listed securities through the other parts of their organization are something which are also worth bearing in mind as we sort of approach this issue. So when it comes to Doneco, I think, like, I personally have difficulties in drawing some policy conclusions from it, or at least clear ones, because ultimately it wasn't the fact that the lender there had acquired an equity interest in the form of the options that ultimately gave rise to the unacceptable circumstances that were held to exist. It was the fact that the lender was in a position to exercise its security, in fact had acquired voting power under the terms that they had in the shares, and the security interest was over a very sizable percentage of the register, and at the same time was engaging in acquisitions on market to build up an almost 10% physical holding in the stock, in circumstances where no one in the market had any awareness of the fact that they were also in a position at any moment to exercise security that would have given them an additional 28%. And I think that to me sticks out, because it doesn't mean you can't approach this topic by just simply saying, I think that this particular type of lender shouldn't get the benefit of this exception, or a type of security arrangement that has certain features, for example, as this one did, a call option over existing shares. I don't think that, like, you can't look at what happened in Doneco and then draw a conclusion from that, which gives you an easy and bright line test that you can follow for trying to determine, when these exceptions shouldn't be available. So, I guess the question that Emma poses is should the panel provide some guidance to the market in order to inform things? So I guess on one view, Doneco speaks for itself. It obviously has a very unique set of facts, but I think anyone who reads the decision would come away, as I did, with the clear impression that the reliance of the exception in those circumstances, in the context of making acquisitions on market on an uninformed basis, was problematic. And they were able to come up with a remedy there that resolved the issues that created. And I think there's a lesson there for the whole market in how not to rely on these exceptions. But what was really unique about the case was that the panel went further and actually called on ASIC to consider how it frames the extension relief that it provides for these exceptions, given that was something that OCP was relying on in that decision. And whilst on the face of it, I can completely understand why the panel members did that. As Emma and I kind of dug into this a bit further, we started to realise just how difficult it is to actually try and define the circumstances where it may or may not be acceptable to be relying on the exceptions. So I don't know how realistic it was to expect ASIC to do anything in response to that. And going one step further, I don't know how realistic it is to set ourselves sort of up a challenge of trying to refine the exceptions further, and with legislative changes to try and deal with this stuff. And I think the fundamental issue which Emma's work sort of draws out is that because of the various changes that have been made to the way these exceptions are drafted, they operate very broadly. Words like financial assistance by any means really do permit a very broad range of commercial activity. And they really aren't just limited to just a traditional lending arrangement. And I think the Doneco decision as well had a really interesting discussion about what in the ordinary course means. And ASIC submissions made the very valid point that you can't simply have a lender who says that this is how we always do it and therefore self-define what's meant by the ordinary course. But Emma's looked at the case law, and what you find is that, well, you kind of can. And so I think the background we've got here is potentially very broad legislative exception. A sort of one particularly egregious example of where these exceptions were relied on to the detriment of participants in the market, a desire by the panel, understandable, to at least see ASIC try to rein it in a little bit. But I think it's very difficult to do that. And so I think that's why Emma's hit on the solution of, well, trying to provide a little bit more guidance to the market around how this works. But I think where Emma and I might differ a little is in how you do that. Because what I don't think it's possible to necessarily create some bright lines that and there's one core reason for that, and perhaps it portrays the fact that I spent a lot of time acting for large global investment banks with very complicated I guess business structures. It's that whilst one arm of their business might have a security interest over, say, a 20% stake in a listed entity, securing a loan that they've made to the holder of that stake, there might be other arms of their business on the other side which are writing swaps and entering into or potentially acquiring the underlying securities themselves to hedge positions that they hold under that. And there's a whole bunch of different transactions that might be going on different arms of the organisation, none of which are done in cahoots with any other arm or towards some sort of overriding control purpose, but which would actually trip up a number of the tests that Emma has outlined in the sort of proposed guidance that the panel would put out.
Adam, sorry, we've lost you.
Oh, I think we've lost Adam there briefly. Could I just remind people while we reconnect with Adam, if possible, if there are questions, by all means, please type them into the chat, and we can use that to direct the attention of Emma in the first instance, and Adam now. There we go. Adam's
Sorry,
back.
I'm hoping I'm back.
Yes, you are.
Sorry about that. I don't know what's going on, but I'll keep it very brief in case the battery on these headphones is going to die. All I was saying is I think really the most you can really say for guidance around this is that it's when you are using the exceptions in a manner which is not directed towards trying to preserve or realize the value of your security. That's the really general principle here. And in Doneco, you know, they were relying on those exceptions, and I know that would no doubt be different views expressed by those advising OCP on that matter. But for all intents and purposes, when you read the facts, it does seem a lot to the outside observer that they were relying on the fact that they didn't have to disclose the security interest at a time when the security was enforceable, to try and build up a stronger position and overall holding that would have allowed them to influence the business affairs of the company. So I think ultimately where I get to is that I don't think you can have bright line tests about 20% below or above and what you can and can't do, because I think that doesn't take into account the fact that a complicated organisation might hold a 25% security interest, but another arm of it might be acquiring 5% via its swap activity. I don't think that there's any mischief in them moving from 25 to 30 on the face of it in those circumstances. So I think we do need to be careful around that. So I think bottom line is, I do think we do continue to need the exceptions. We do want to ensure that large holdings can be, you can provide liquidity for those things. And I think that to the extent there is additional guidance around this, I think it should be a more general message that relying on these unconscientiously or for purposes ulterior to the preservation and realization of your security are the sorts of things that would result in a loss of it with the implications that flow. And that is all from me.
Thank you, Adam. Thank you very much for that. And Emma, perhaps do you want to come back on screen? We have one question from Alan Shaw, but I'll ask a broader question first and then come back to Alan's. Look, as someone who approaches this as an interested outsider, I guess one of the questions I always ask myself is, are we looking here at kind of unintended consequences? We kind of know why these exceptions were thought of, and why they make sense. And then the market being what it is, and market participants being what they are, people will attempt to use the loopholes or the exceptions in ways that were not really what they were intended for. And so are your recommendations, Emma, driven from kind of just a desire to address unintended consequences, or are there real, I think Adam called them mischiefs, out there that you think need to be reined in, that either are occurring already or could potentially occur? It's probably a question for both of you, actually.
Thanks, Scott. I think that in terms of unintended consequences, I think it's more that the exception is needed there. The difficulty is in takeovers, you have to weigh up different policy considerations. And so while the law technically does allow the lenders to take the equity positions, the concern is that because their security interest hasn't been disclosed, then that can lead to their misuse of the provisions. So I wouldn't say that's unintended consequences. The exceptions as they were drafted early on in time were narrower. But I do think that there has been an expectation since 1991, so before the provision was actually extended to financial accommodations by any means, that this would apply to allow the lenders to take an equity position.
I agree, Emma. I mean, I just think that with all of these exceptions to takeover rules, there's always a risk of abuse, and I think there's a large body of panel guidance and case law decisions that go to trying to articulate where the limits of reliance might be. And all this is just yet another example of how to try and rein in potential abuse of two exceptions that have a very valid, reason for being.
Thank you. Okay. So to Alan's question, thanks very much for an interesting discussion. Problem of timing in Doneco. What about adopting a position that acquisitions of securities by a lender are allowed, but reduce the ability to exercise that percentage of the security interest with disclosure at any level, not just at the 5% level? Abuses could still give rise to unacceptable circumstances. Would that suggestion address your issues, Emma, in a similar way?
It would certainly address the question of control overall. I guess I'm not sure, and this is the disadvantage of being online, the disclosure at any level, not just 5%. I wasn't quite, you're assuming that you're talking about any particular acquisition of security, even if it's below the 5% level. Now, something that Adam and I were talking about was the fact that if you have special rules for the lenders where they're starting to disclose acquisitions below that 5% threshold, then it signals to the market that the securities interest is there anyway. So, yes, it is quite complex, but that's... Adam, did you want to comment?
No, I was going to say the exact same thing, Emma, like that we had that thought. And I guess one of the more, I mean, if we wanted to sort of try and think differently about this, one question that I've been mulling over is, well, what would happen if kind of we just decided that you just don't have a disclosure exception at all for this? Now, clearly the big risk with particularly margin lending type arrangements is that if short sellers were very well aware of the sort of large margin lending positions and stuff, then there's potential for them to target the stock, as we saw during the GFC in 2008 to great effect. But I do recall at the time that both ASIC and ASX got very concerned and actually put out some joint guidance that essentially said that if you're an ASX listed company and you're aware of some of your directors having these sorts of positions in place, you need to consider whether that information is materially price sensitive. So I guess a long story short is a way of thinking about this is working out whether we do need the disclosure exception. Should we, as a sort of market, remove that, create more transparency, have a more informed market, and that may well encourage sort of people to include some additional disclosure that gives the market comfort that there isn't a hair trigger that could result in the security holder all of a sudden dumping a bunch of shares. For example, making it clear that it isn't a margin lending arrangement. There isn't the ability to call for additional collateral, that kind of thing. I don't know. I mean, I haven't really been able to think that through, but it's something that has occurred to me that is something that, if you were looking very hard at this exception, whether or not the justification for that is still there.
Thank you, Adam. Are there any other questions from the audience? Got a terrific audience today, which is fantastic, including a large number of names that the participants all recognise, which is fantastic. I guess one of the things that I'm curious about is that we talk about markets sometimes in and Adam, you haven't done this, but in sort of quite naive terms as there's shareholders and there's blenders and all the rest of it. And of course, what Adam's pointed out is that you can have some very complicated arrangements with investment banks, with hedge funds, all of whom might have multiple different interests in any particular set of transactions or any particular set of circumstances. And the other part of it, of course, is that these things can happen very quickly. And with not great transparency, both here and offshore. There could be all sorts of things. To what extent do you think that we can cope with that level of complexity now? Can any set of rules really deal with something where the transparency is that potentially problematic, where transactions can happen at such pace, particularly hedge funds and the relationship hedge funds have with investment banks?
I don't think they can, which is why my view on this is that to the extent that you can provide guidance, I think it is just issuing a warning that relying on these exceptions to achieve objectives that go beyond preserving or realizing the value of your security can give rise to, orders that are adverse to your interests. I think it is very difficult to do this.
So if I understand that, what you're in a sense suggesting that you probably try to make the guidance more scary than you might otherwise. If you could be certain of what was going on and you could track it in real time more effectively, you might be content with slightly less sort of prophylactic kind of, don't do this type warnings.
Well, I guess. I mean, I think that there's a huge amount of complex activity going on, every day. But the overwhelming majority of that isn't something that gives rise to the sort of policy concerns that our takeover laws are concerned with. Really, this is about people taking advantage of these exceptions in order to acquire influence or voting power or help someone else acquire those things in a manner that they wouldn't otherwise have been able to do without disclosure.
Sorry,
yes, Adam and I talked about the niche nature of these types of lending arrangements, and that's why I drew the comparison with the rights issues, which on their face are covered by the exception, but the extent to which they can be in particular circumstances be misused, depending upon the effect on control and the size of the interests which are involved. Sorry, Scott.
I'm just keen to hear any last questions that we might have from the audience. We have a minute or two before we wrap up at 5:02. And I appreciate that sometimes it takes a little longer to type the questions in than it might to speak them. Apologies for that. Okay, well, in the case that there aren't, remains for me to thank Adam and Emma for their presentations and for their thoughtful answers to our questions. Thank you very much for that. As I announced at the outset, the slides that you've seen will be available to attendees perhaps sometimes later on this afternoon or tomorrow. So I look forward to that. Obviously, if any questions come up to you after this, having thought about it and ruminated over the afternoon or whatever, please, I'm sure both of our speakers will be very happy to hear those questions and continue the discussion. It's clearly one that's got lots of different dimensions. So remains for me to say thank you very much to everybody for participating, for the speakers for giving us their thoughts, for Tom for managing to keep the technology running.
Notwithstanding my best efforts.
And please stay safe, stay well. The centre does run webinars on a variety of different issues and we'll be running some over the course of the next month. So keep an eye out for that. And we look forward to seeing you next time.
Thanks, everyone.
Thank you very much, everyone.
Thank you.
Bye.